the facts of the case of Feldhaus versus Binley. So the complainant, Paul Feldhaus, had a conversation with his nephew, which is John Feldhaus, about buying his horse. After their discussion, the uncle replied by letter stating that if he didn't hear any more from his nephew concerning the horse, he would consider acceptance of the order done, and he would own the horse. His nephew did not reply to this letter because he was busy at auctions. The defendant, Mr. Binley, ran the auctions and the nephew advised him not to sell the horse. However, by accident, he ended up selling the horse to someone else.
The legal issue in Feldhaus versus Binley was whether Mr. Feldhaus and his nephew had binding contract for the sale of the horse, and the other one is whether Mr. Binley was liable for conversion for selling the horse to someone else. The main issue in this case was whether plaintiff's nephew accepted the offer validly. Plaintiff claimed his nephew accepted the offer by instructing the defendant not to sell the horse to anybody else. And another issue was whether defendant was liable for conversion. Plaintiff said that he was the rightful owner of the horse and that defendant had wrongfully sold it to someone else. However, defendant claimed he had behaved in good faith and had no cause to believe he was wrong. Contract law and tort law are among the areas of law at stake in this issue. Contract law was used to determine whether Mr. Feldhaus and his nephew had a binding contract for the sale of the horse, and the tort law was used to determine whether Mr. Binley was liable for conversion because he sold the horse to another person.
In the case of Feldhaus versus Binley, the legal judgment rendered by the court in 1862 was in favor of the defendant, Mr. Binley. The court found that the mere silence or inaction of the nephew, Mr. John Feldhaus, did not amount to acceptance of the offer. Mr. Paul Feldhaus' statement that the horse would be considered sold. The court emphasized that acceptance must be communicated explicitly and cannot be inferred from silence alone. Therefore, the judgment in Feldhaus versus Binley was in favor of the defendant, ruling that there was no valid contract between the parties. This case established the principle that acceptance must be communicated. Ultimately, Mr. Binley was not liable for conversion for selling the horse to someone else.
The court's reasoning in Feldhaus versus Binley was based on the principles of offer, acceptance, and consideration, which are essential elements of a valid contract. The court applied these principles to determine whether a contract had been formed between Mr. Paul Feldhaus and Mr. John Feldhaus for the sale of the horse. However, the court first determined that Paul's letter offering to buy the horse was merely an offer and not a binding agreement. This is due to the Contract Act 1950 under Section 10. In order to form a legal contract, 6 specific elements are needed to exist, which are offer, acceptance, intention to create a legal relation, consideration, certainty, and capacity. Prior to that, the court held that some of the elements were not satisfied in the case, making the contract to not bind perfectly. In addition, under the Contract Act 1950, Section 7 states acceptance must be expressed in some usual and reasonable manner, can be done in any method, either oral or writing. However, silence cannot be considered as an acceptance. The court also held that Paul's statement that he would consider the offer accepted if he did not hear back was not a valid acceptance either. On the other side, the liability of the auctioneer or Mr. Binley was based on the principle of agency law. He was entrusted as an auctioneer to sell horses at the bidding platform. Because of the court already confirms that there is no legal transfer ownership between the uncle and the nephew, the auctioneer was not responsible for selling it to a different buyer. Hence, the auctioneer was not held accountable for the uncle's loss according to the court because he was working correctly in his role as the nephew's agent.
From this case, we know that silence does not constitute acceptance of the offer. According to the Contract Act 1950 under Section 7, acceptance must be made in some usual and reasonable manner, either by oral or writing. So, since the acceptance did not come from the nephew, the contract between the nephew and his uncle did not conclude a legal agreement, because offer and acceptance of the offer are necessary for a contract between parties to be legally binding. Therefore, the case was subsequently dismissed.